Well, hello, everybody. This is another edition of Zoom Landlord-Tenant Talk Radio. It's our first one in the year 2024. Glad everybody could join. In case you're curious, the song I was playing was Dan Fogelberg, and it was called Same Old Lang Syne. I asked my kids yesterday when we were having a home meeting. And I asked them, do you know what Old Lang Syne means? And they never even heard of the expression, but I guess if we're older, we do, and it means from an old time past. And I played that song because it's basically, this one is called The Same Old Lang Syne, and that's what we're getting with regard to the new laws that have come across in the state of California for the year 2024. One particularly ugly Senate bill is 267. So what is this new hurt that is being foisted upon landlords at this point? And this deals with government subsidized housing. Now, many of us know what Section 8 is, and that's what a government subsidized housing is, where an applicant, a tenant, will apply because of his income status to be subsidized, and he'll take his voucher to a landlord and say, hey, I'm going to be able to pay the rent because the government's basically going to be paying 90% and I'm only going to be paying 10%. A lot of my clients, I have told them that I don't know what a great policy that is in terms of taking Section 8 tenants. I have many clients that do, and they have a great business model off of that. But a lot of times landlords were reticent to take Section 8 tenants, government subsidized housing, not because they weren't sure that the government was going to pay them, but you had issues that you had to deal with all of the government requirements. There's a ton of forms to fill out. There's annual inspections. And it just becomes very difficult for landlords to operate their business when you have basically Big Brother in your pocket. If, for example, they would have inspections that were recalled, and if the tenant wouldn't let the housing inspector in, then the person who would be harmed would be the landlord, because they would cut you off with regard to your subsidized payments. In addition, if you wanted a rent increase, and even, for example, the silly amount that, for example, the city of Los Angeles is allowing, 4%, you don't even get that under Section 8. You have to get approval from Section 8 for any rent increases. So I've always told my clients that it's not the best business model, at least in my opinion. And I think most of my clients agreed with that situation. So I always told them that just shy away from that. Well, unfortunately, a couple of years ago, the state of California passed a law which says that you could not summarily reject a Section 8 applicant. You couldn't use that as your only criteria as to why you wouldn't take this applicant as to be one of your tenants. And I would always say to my clients, don't worry about that law. If you have a Section 8 applicant, make sure you take their application. Don't just summarily reject it. And then what you do is check out their credit. Invariably, their credit's going to be bad. And God knows that any person who's extending credit from a bank with lenders, or from a landlord who's extending their $250,000 apartment unit, which they average go for or more, we are allowed to check someone's credit. And if their credit is bad, then we could reject that applicant, unless we deal with the new law of Senate Bill 267, which talks about those applicants which have subsidized housing. So if you're taking now, you can't even make this up, ladies and gentlemen, if you're taking now a Section 8 tenant, you cannot use the criteria that he has terrible credit. He's got a credit score of 505. God knows I would never take anything like that. And credit scores are not just, quote, that he's got bad credit and therefore he will not pay you. Credit scores also indicate whether the person is good with his finances, whether he will take seriously his obligations. You know, somebody might have a lot of money and just chooses not to pay their credit card bill. That doesn't, and even though they have the money, but right now we cannot solely use credit as a method of rejecting Section 8 applicants or government subsidized applicants. So what does the government say that we can use? Well, they have this new criteria called the ability to pay. The ability to pay. Now, what does that mean, ladies and gentlemen? Well, I'll tell you what it means. It deals with the fact that if the tenant can show verifiable sources of income, which shows that he will have the money to pay you, then you have to take him. So our catch-all reason, well, he probably has bad credit and I don't want to take him. Now, if he can show that he can make the rent payment, which for subsidized housing, let's just pretend it's going to be $200, that the rent is $2,000, the government pays $1,800 and the tenant. If the tenant can show, quote, verified sources of income, then you can't take their credit into consideration. Now, this is crazy, ladies and gentlemen, because again, credit worthiness and having a bad credit score shows a lot of other things than just merely, quote, whether you're going to get paid or not. And you can have a situation where a tenant has the money and just chooses not to pay all of his other bills, and therefore his credit is bad. So just centering it on, quote, the ability to pay really is not the way to go. Not the way to go, ladies and gentlemen. But this is where we're forced to live with under this new rule. I do have a secret way of getting so that you do not have to take a Section 8 tenant if you don't want one. And that is, and I've been advising this for landlords, especially under statewide rent control and under certain cities like the city of Los Angeles. One of the criteria that I'm telling clients not to do, and it does sound strange, is do not lease a new unit on a 1-year lease. I know that sounds crazy. Of course we're going to do a 1-year lease. Well, not anymore, ladies and gentlemen, not based on the way the politicians are running. So do everything on a month-to-month tenancy. By the way, if a tenant leaves before the year's out, you're probably not going to chase him for his money anyway. So it's only a protection for the tenant. And you see in the city of Los Angeles, if you have a non-rent control building, if he's been there less than 6 months, you don't have to have cause to evict. The same thing is true for statewide rent control. If your building is subject to statewide rent control and the tenant has been there less than 1 year, then you can just terminate the tenancy with a 30-day notice. But if you're on a 1-year lease, you're dead. Now, with regard to Section 8, and why is that the salvation to Section 8 is Section 8 will not allow a tenant to move in on a month-to-month tenancy. So one way to get around taking Section 8 tenants, but you need to do this for all of your units, and I'm recommending that you do this for all of your units based on other laws, is say to the tenant, I'm happy to take you. You have shown me an ability to pay, even though your credit is terrible, but I'm only going to do this on a month-to-month tenancy. So based on that, I don't think you'll be able to have to take Section 8 tenancies. Again, I have clients who think that this is a wonderful plan, a business model to take them, and I have a lot that don't. Anyway, that's the monologue for this Saturday, which is what, January 6th today. We're gonna start opening up the lines for people to talk. We do have some ground rules, and that is that this Zoom meeting is for informational purposes only. It's not a substitute for getting real legal advice. If you need legal advice, please contact an attorney, such as our office, and we're happy to listen specifically to your problem. If you do want to talk, please electronically raise your hand, and I'm happy to call on you. I'm going to try to get to everybody today. And please do not talk unless I'm calling upon you. If I am, then please unmute yourself. If you're calling in on a cell phone or a regular landline and you want to unmute yourself, it's *6. If you're calling in on a Zoom meeting, then you're just going to click the button that says unmute yourself. And with that being said, I want to move over to Jeff and Takeo. We talked to you last week. I'm going to ask you to unmute yourself. And are you there?
Yes, we are. Hey,
Hi,
thanks. Hi, good to see you again.
good to see you.
So, last week we talked about a tenant in a back unit and tenants in the front unit, and you suggested that the possibility of once we get the guy out of the back unit, then would be we could revert the property to a single family resident, and then under statewide control, we'd be able to ask them to leave without the same just cause requirements. So we just wanted to confirm that and then ask, does it, we were gonna ask what you were kind of talking about earlier, a year to year, month to month or a yearly lease, does it make a difference?
Well,
What are
first
the
of
pros and
all,
cons? Like they're on a year lease right now on the front.
yeah, Jeff, what city are we talking about?
Oh yeah, that's Hawthorne again. Yeah,
What is that?
Hawthorne.
Hawthorne. Okay, well, obviously, if a tenant's on a year lease, he has property rights, and I'm a firm believer in property rights, so he gets to stay there until the lease is over. Once he's been there, if it's a single family home, then it would not be considered under statewide rent control. But right now, it's not a single family home. You got 2 units on one lot. So, and even though that second unit, as I remember, was not, quote, a legal unit, it still constitutes 2 units on one lot. So your job is to either make a deal with that tenant in the rear unit to get him to go, pay him to get out, or, as I think I told you, get yourself cited by building and safety by the city of Hawthorne, and where they'll declare that to be an illegal unit. Then what we can do is merely serve on that tenant a 60-day notice to vacate. We need to pay him relocation, which is 1 month's rent, not a big deal. Once he's out, you're going to take out the toilet, the sink, all those items, those that you put in there that were not without permit. Once those are out, then it just reverts back to whatever it was, which is probably like a recreational room or some other situation, but it's not considered a dwelling unit. Then once your lease is over, which is coming up in March, then we can either raise the rent to market level, make it higher rent, or if it is declared not under statewide rent control, it's a simple matter of serving a 60-day notice to get out.
Does that now, even in the front, they're on a yearly lease, so do we have to wait another full year in order to get them out of the front unit?
I thought the front unit was the unit that was up until March.
Yeah, it is, yeah.
Okay, and the
That's
back unit is
less,
also on a lease?
yeah, they're on month to month,
Okay.
not
Oh, well, they're month to month. So yeah, so not, you have to wait for the front unit's lease to be over. Again, that's property rights. They're entitled,
yeah.
as long as they don't make a mistake, they have just as much rights as anybody else who's an owner if you leased it to them. So bottom line is that we need to work on the back house.
And we can
Anyway,
change them to month at the end of March. Is that possible to just to change over
yeah,
the
it'll
lease to a
come,
month? Okay.
when a lease expires, it automatically becomes month to month by operation of law.
Okay, good. Thank you very much.
Thank you. Okay, let's move on. Let's see here. Kathy Yu. Hello, Kathy Yu. If you'd unmute yourself, please. Kathy Yu, come on down. Please unmute yourself.
Okay, can you hear me?
I can. Look at you. Oh,
Okay,
wait, I can't look at you.
I know. I have a situation in El Monte. The lease start at May 10, 2023, and then expire in February 29, 24. So, when the lease end, what need I need to do? Because if the tenant won't move out, what happen? Then if she
Okay.
pay me rent, should I take it? And if she pay me that sale, how do I reject it?
Okay, well, first of all, this is a lease that starts May 10th and ends the end of February. Is that correct?
Yes, uh-huh,
Okay, so that means that it's less than a year's rent, less than a year.
right.
So what you need to do is right now, today, send that tenant a letter. State it's just an informal letter saying, hey, your rental agreement is over as of February 29th, 2024, and I'm giving you a heads up. I'm not renewing, so I expect you to go. Do not accept any rent for the month of March. You said, but what if they sell it to me? If they sell it to you, that's not a big deal. Everybody says, oh my God, the money's in my account, I'm stuck. You're not stuck. You did not take a check and bring it to your bank and cash the check. This was an unauthorized deposit by use of Zelle, which I'm a big fan of, where they put the money in your account. If you can Zelle it back, Zelle it back. If you can't Zelle it back, then it's very simple. What you're going to do is you're going to write your personal check to the tenant with a little note that says, you've made an unauthorized deposit into my account, here's the money back, and mail it back to them. If they don't cash your check, I don't care, because we're going to, on March 1st, we're going to file the eviction lawsuit based on something called termination of tenancy. You don't have to serve any kind of a notice on them other than this informal letter that you should do right now today. Get that letter to them telling them that you're not going to renew their lease.
Okay. Can I ask one more question?
Sure.
I
The
want to
price
find,
is right here.
okay, I want to find out that, the tenant always call us that they get locked out because they've lost a key or something. Now, if we don't go there and open for them, and in case there's anything happen to them, if they are waiting outside the unit, so is the landlord be responsible?
Well, I think part of the duties of a landlord is that if tenant is locked out, to open up the door. I might want to put into your contract the next time you do a rental agreement that if the landlord is called to have to open up the door, we're going to consider that a service charge, and I'm going to charge you $75 or some reasonable amount. But otherwise, I do think that the landlord has an obligation to open up the door for the tenant. Maybe they should put an electronic lock on it where they can just do it on their cell phone, as many places do. But in any event, I don't see an issue with that, where if you had that in your rental agreement that you could do it. However, is there any, quote, liability to the landlord? I don't know. I don't think so, but I think that is your responsibility. If it's abusive, I might change my mind on those issues. Anyway, thank you very much, Kathy. I am going to move on now. Let's take our legacy participant, Dina. How are you, Dina? And hopefully we have a different question today.
Oh, yeah, we do. Hi, Dennis. Well,
Hi.
actually, my question today, thank you so much for sharing your perspective about this issue of the new law, which is crazy. But here's my question. If we get a tenant and then we're going to tell them, okay, your ability of pay is good and credit, but we are renting month to month, should we let the tenant know that we know upfront that renting month to month is something not accepted by the what you call it, the Section 8
Well,
rule?
no, I wouldn't say that to them. But again, we have to have our policies consistent. So
Yeah.
if you're going to just do it for Section 8, that's going to
No.
that's going to be considered discrimination.
Yeah,
So
yeah.
I wouldn't make reference to Section 8. I'm just going to tell everybody, you might even put it into your ads that this is we only lease on month-to-month basis.
Okay.
That would prevent you from getting Section 8, but also has the other advantage for if it's a non-rent control building in Los Angeles. Now, after 3 months, the guy's sitting there and I see him, he's being very disrespectful to me, starts screaming at me. It's not enough for me to do an eviction. That's not going to be cause to eviction. But you see, for the first 6 months for non-rent controlled units in the city of Los Angeles, I could just serve you with a 30-day notice, get off my property. That's also true for statewide rent control, where if you've been there less than 1 year. So I think the government is encouraging us on so many levels not to lease on a year lease. And again, what's the advantage of a year lease? What is the advantage? The advantage is, well, I'm sure that the guy's going to pay me rent for 1 year. That's the only advantage to the landlord. But then the guy leaves at the end of 6 months. Are you chasing him for the money? And the answer is probably not. You're not going to go, oh, you owe me 6 more months. Oh, wait a second. It only took me another month to rent it out, so you owe me 1 month. You're not going after him. So the 1 year lease, I think, is a disadvantage to landlords. And I understand that this is 100 years of people saying, I got to get you on a 1 year lease. I'm not doing month to month. But you know what? Times change. We're in 2024. And with all these rules and regulations, I think it's to your advantage not to do that.
I have one more question regarding something of last time, last Zoom, where a lady, she asked and you told her that the condominium is not a single family resident, but my understanding, if the condominium is an alienable and separate deed than the others, then it is considered single family and it's exempt.
I think you're just making a mistake with language, okay?
Okay,
If you're talking about under California law, the ability to raise the rent, you
yes,
can raise the rent to whatever you like, if it's a townhouse, condominium, or a single family residence. There is no
Okay.
law which prevents you from raising it to market level or to whatever you want. Those types of units are alienable. That is, that you can sell the unit to that specific unit, even though there's 40 condominiums in the building or 40 townhouses
right.
on one lot, you can still sell yours. But
Now-
what I think you might have been confused about,
The just cause, because it's exempt.
right,
from
if
the
your,
just
well, let me finish. If your
Yeah.
property was built prior to, in the city of Los Angeles, prior to October 1st, 1978, your property is under rent control unless it's a single family home. Townhouses and condominiums are subject to the rent stabilization ordinance, which means you have to register your units each year and you have to abide by their eviction protection rules. You are not limited, even though you're under RSO, the rent stabilization ordinance, you are not subject to rent limitations, but you still have to register that unit. If you had a condominium that was built in 1980, okay, now you're not subject to the rent stabilization ordinance. You can, of course, in all situations, raise the rent to market value. Okay. But now, of course, the city of Los Angeles has now started just cause evictions for every residential unit where the person has occupied the unit for more than 6 months. So in
Okay.
any event, this is what we're saddled with, and that's the explanation with regards
So,
to.
but this is the city of Los Angeles, not the county. If we are incorporated city in the county and not Los Angeles, so we are still exempt with the just cause, or we're okay.
Okay, if you, for example, let's just take a city, El Monte, which is an incorporated city. It's not unincorporated, it's an incorporated city.
Yeah.
Just like Torrance is, and Hawthorne is.
Yeah.
In those situations, if you have a townhouse or a condominium or a single family residence, you are not subject to statewide rent control as long as you advise the tenant in his written rental agreement that you
Right.
are not subject to statewide rent control. So you don't need to have a reason to tell them to move, and you don't have you can raise the rents to whatever you like, obviously, for that situation.
With the just cause exemption. Okay. Thank you so much.
You're very kind. Let me move on here. Bear with me. Where are you, young lady? There we go. Oh, you already are. Okay, let's move on to Ashok Madan. Ashok Madan, I'm going to ask you to unmute yourself.
Okay, I have a quick question. We had to do some repairs in the unit and had to relocate the tenant. And we are paying for we agreed to pay for the relocation wherever she is moving, but isn't she obligated to pay the rent if it, let's say, it takes 3-4 months to do the repairs?
If you're going to pay for her lodging someplace else, then I would believe that she is responsible to pay the rent. Now, what city are we talking about?
Los Angeles.
Okay, yeah. So she is obligated to pay the rent. You're obligated to put her up
Okay.
in a place, especially since it's going to take longer than 30 days to complete.
And if she doesn't pay, what do we do?
Well, technically, you could start an eviction based
Okay,
on that.
Okay,
Excuse me?
that's what the other question is real quick. There's a tenant, she pays less than half the market rent, and she sent her son's application. She want him to move in because she wants to go take care of her elderly mother out of town on the East Coast. So are we obligated to let him stay there? We don't, we rather
Well, this is the city of Los Angeles,
Yes, sir.
and it's under rent stabilization.
Correct.
They have the right to bring in another person. You have the right to check their sources, their credit. And if in fact their credit is okay, then you have to allow that person to move in. However, if your tenant is permanently moving out and she's just really trying to substitute one for the other, then you can do something with that to evict that person. But technically under the city rules, you're allowed to bring one person in, but the landlord, prior to putting them in, the landlord has the right to check their credit.
Oh, I think one of these sessions you said that you can start eviction if you don't want to do the 10% rent increase.
You're right, but in that situation, the city of Los Angeles does allow you to add it to an extra 10%, which might be another great remedy. But in that situation, the way it was told was that this person moved in. You can't just move in. Okay, you got to tell the landlord, give the landlord a chance to check the credit and other items to approve it. Once it's approved, then he has to go in, and the landlord can't unreasonably withhold. But if you just move in, what are you doing here? Who are you? Well, I moved in. Well, then I could serve you with a notice to perform or quit. And if that stranger doesn't move out at the end of the third day, we have the right to evict.
Yeah, but I don't want to process his application. He did submit, but are we obligated to process it?
Yes, of course, because if he hasn't moved, has he moved in already?
I don't know. He might have. I don't know.
Well, then, well, let's pretend he has moved in. If he has moved in and you haven't approved it, then you have the right to start an eviction. But if he hasn't moved in, and if you don't want to process the application, then he's going to have the right to move in. Simple as that.
Yeah, he can. Yeah. Well, let me find out if he moved in, but I don't want
well,
to.
guess what? I'm going to be here next week, same time. You can call me back or call the office.
Thank you.
All right.
Yeah,
Thanks, Ashok.
Thank you.
Good questions. All right. Who are we talking to now? I see. Let's move over to a cell phone, which ends 4379. I'm going to ask you to unmute yourself by hitting *6. *6. How are we doing? Mr. Cell Phone, ending 4379. Okay. Okay, we're going to move on. We tried. Let's move on to Anna. Anna, oh, there you go. Are you there, Mr. Cell Phone?
Yes, I'm here. How are you doing today?
Good. You were just 1 second away from getting cut off. Look at you.
I have a kind of complicated situation, but I'm going to kind of go quickly as possible. I had an attorney working on an eviction for me that I gave the tenant a 3-day notice back in December of 2022.
Whoa. Still working on that one?
Yeah, she was working on it for me. It took her 3 months to file the eviction. She didn't file the eviction until March 1st, 2023. We were only asking for the month of December in the 3-day notice.
What city?
The city of Los Angeles.
And you were asking for rent from December of 2022?
Yes. It was December 2022 when I issued the 3-day notice.
However, you understood that at that point in time, the city had a moratorium for evictions based on COVID.
Yes, the attorney to me didn't really, I don't think she advised me properly, because the tenant did give me an inability to pay rent.
Due to COVID.
We also got due to COVID, and then the tenant also went to the city of Los Angeles, and the city of Los Angeles sent me a letter telling me that the tenant had rights and do not evict, but the attorney still allowed the eviction to proceed. Anyway, back in January, the tenant sent me some type of notice, 15-day to cure notice, some kind of notice.
The tenant sent you a 15-day notice?
The tenant sent me a 15-day notice telling me to, I guess, stop the eviction or whatever it was.
Right,
some type of 15-day notice.
Let me stop you here, because we're going further than we need to go. Okay. If the tenant sent you a letter saying that they had an inability to pay, the city of Los Angeles ended their moratorium, kind of, in February of 2023. You're asking for rent from December of 2022. So, and the tenant has
Yeah.
already advised you that they had an inability to pay due to COVID. By the way, biggest lie in the planet that in December of 2022, you're impacted financially because of COVID. I mean, it's an absolute lie. It's just insanity what the city rules are. However, since they gave you that letter, you've got one choice, okay? And then you get a letter from the city telling you can't do it. You got one choice, my friend. What you do? You dismiss that case faster than you can spit.
No, but let me tell you what let me tell you what happened. Okay, the case proceeded the entire year of 2023. In December, there was an issue with the 3-day notice where it did not have some type of language excluding Saturdays, Sundays, judicial holidays. The defendant asked for a motion on the pleadings, and it was granted. The judge entered judgment against me in the case. So the case was there. It wasn't dismissed. It was a judgment entered against me. So now the attorney is telling me that we can't go back and ask for December, obviously, because it's more than a year, and now we may not be able to ask for rent in 2023 because there was no lease. The lease was terminated. So I don't know what to do at this point.
Well, number one, the first thing you do with all speed is you fire that attorney. Okay, I don't care where you go. You can't get worse advice than that. So not only could you not legally ask for the rent because it was during the COVID period, but the landlord's attorney, your attorney, didn't have the proper language in a 3-day notice. The language in a 3-day notice has to say that when counting 3 days, it excludes Saturdays, Sundays, and judicial holidays. So that case was doomed. And for the other side did what they call a motion for judgment on the pleadings, which basically is telling the world, hey, Your Honor, we don't need to have a trial. Just take a look at that notice. It's defective. And when you have a defective notice in an unlawful detainer, a notice is similar to the foundation of a house.
Okay.
If you build on a faulty foundation, the Taj Mahal, okay, it's a beautiful structure. Everything's perfect. If it's built on a faulty foundation, you've got to tear that house down. The same thing is true with an unlawful detainer. If you have a bad notice, there's nothing you can do other than to dismiss that case. So that case now, you should have dismissed it because I don't know if there was an attorney on the other side, but if there was, they can get attorney's fees against you depending on the language in your rental agreement.
Well, they are suing me now for I think it's called retaliation or malicious prosecution for prosecuting a case that wasn't valid, I guess.
Well, but I don't see that as being malicious. However, if you need some help with that, because I don't think an insurance company would handle that for you. I don't see it as malicious. I think it's, hey, I got stupid advice from my attorney. So I think that you can get out of that lawsuit. But right now, this tenant still probably hasn't paid you rent, correct?
No, the tenant hasn't.
So what we need to do is we need to start an eviction right now, this second, asking for rent from April 2023 past the moratorium situation through January. So I think that's like 10 months. We'll serve a 3-day notice and we'll proceed forward with an eviction. So I would suggest calling an attorney, and I would be one that would be happy to help you. I am going to move on, but because I think we've explored your problem pretty well. All right. Thank you so much. And I'm going to ask you to lower your hand. Let's move on to Anna. Hello, Anna. I'm going to ask you to unmute yourself.
Hello, Davis.
Hello, Anna.
How are you?
I'm doing good on a Saturday, even though those pesky Lakers lost again, and now I got to play the Clippers tomorrow. So
thank you for you give us opportunity every Saturday. Davis, I have a question. Do you handling the case beside of evictions, like a landlord-tenant sue case, like if tenant suing landlords, those type of?
we handle those all the time. A lot of tenants are bringing forth lawsuits based on that the premises were uninhabitable, or like the last caller where it is, where they're claiming harassment and all this other basic garbage. So if you do ever have a lawsuit like that, we are happy to assist you. We'll also assist you to see how much we can deal with your insurance company on that. So it's always best if you give us a call. We're
You
certainly
work
able
with
to help you.
insurance companies too.
What's
You
that?
you work with landlord insurance companies too.
Of course, yes. We work with them and see what we can do to get the landlord off the hook in the shortest possible time.
Mr. Davis, how can I get appointment? Because I called 3-4 times. I'm not able to speak anybody in office. What's the best way for I can get appointment for next week? I want to come for consultation.
Well, generally, I don't think you'll need to come in. If you've already been received a lawsuit, then basically you could just forward it over to us with your phone number and we'll call you. However, and I've said this before to just to you and nobody else listening. Okay, I'm kidding. But if anybody wants me, because our phones we're answering 200 calls a day. So there's a lot of people who do get through 200 calls a day between all of us, quote, office attorneys. But if you want me, call me between 7 to 8 a.m. Monday through Friday, 7 to 8 a.m. Monday through Friday only. And if you do, just hit my extension 1001. You'll be connected to me immediately. Do not use my extension unless it's 7 to 8 a.m. Monday through Friday. As soon as the recording comes on, and you'll get me, Anna. So try it on Monday. Okay.
Mr. Davis, unfortunately, that's the best time, bad time for I'm driving to work that time. That's the reason for I'm not able to.
You know, there's something called a cell phone.
I know.
All right, so call me on your cell phone and then we'll get back
Okay.
to you. Then you can give me your phone number and I'll call you back.
Oh, I
another
can get
time.
appointment with you. Okay, got it.
Yeah.
Thank you.
All
Yeah.
right. You take care, darling. Okay, let's move on. You know, I really like it when you guys open up your video. You get to see me, you know. Did I ever tell you behind me? I think it's, well, what is it? My left shoulder, that shoulder. You see all the Laker championship newspapers, in case you're curious as to what that is. Over my right shoulder, you get to see where I made the front page of the LA Times many years ago. So, of course, I have that frame, but that's a little bit about what's going on in the background in my room. Let's move over to the 2207 president, Kim Stang. I'm going to ask you to unmute yourself.
Hi, good afternoon, Dennis. How are you doing?
I can't complain, sir.
Good. That's good to hear. Okay. So I have a property in Pomona, California. The tenant right now is on a fixed lease that we signed on March 1st, 2023, and it's to end in this upcoming March 1st. And my question is, my grandfather needs a place to live. So is there a way for us to get the tenants currently living in the unit out and get him in?
And the answer is, this is you said your grandfather? Who is it?
Yes, it was my grandfather.
Okay. This is a single family home?
Yes, single family.
Only one house on the lot?
Yes, only one.
And the lease was entered into in March of 2023?
Correct.
Okay. In your lease, it was a 1-year lease, right?
Yes, it's a 1-year lease.
In your lease, did you have a phrase in that lease that this property is not subject to statewide rent control?
I don't think so, no.
Okay, it's a little trick that even though I keep saying if you're a townhouse, if you're a condominium, if you're a single family residence, you're not subject to statewide rent control. Well, you're not if you have a phrase in your rental agreement which informs the tenant that this property is not subject to statewide rent control. By the way, that's an addendum that I have it on my website, and you can just attach it to any rental agreement unless your rental agreement has that language in it. So if you don't have that language in it, then your tenant is under the protection of statewide rent control, but don't despair. when your lease is up, and let's just pretend it's up March 31st or February 29th, one of the two. Is it February 29th? Is this a leap year? Anybody know? This is a leap year? I don't even know. But the end of February, wait till the end of February. And then what we can do is we can serve a 60-day notice to your tenant, telling him that grandpa's moving in and that he is entitled to relocation, which is a whopping 1 month's rent, not a big deal. And we'll tell him that for the month of March, you pay me. For the month of April, it's free. So you don't have to actually take money out of your pocket. And that tenant will have to go. So grandpa easily can move in, even if you don't have that phrase in your rental agreement.
Thank you so much. Makes it
All
so
right.
much clearer.
Good question. Thank you. Okay, let's move on. I see Sal. Sal, how are you? Let's ask you to unmute yourself.
Hi there, can you hear me now?
I hear you wonderfully, Sal.
Great. Okay, I'm gonna start my camera.
Oh my God, thank you. I like
I'll
to see
try.
other people too. And people
I'll
get
try,
tired
let's
of just
see.
looking at me, by the way, I'm sure.
Somehow I wasn't able to start, but it's no big loss. Believe me, it's no big loss. I have a situation. I have a 6-unit apartment in Los Angeles, rent controlled.
Mhm.
One of the units was set on fire by the tenant. The tenant is we don't have an issue with that because that tenant is going to come in, get their stuff, and leave the unit. But the other 5 units have rent control tenants, and as a result of the fire, we did testing for asbestos and lead, which was found in 2 of the units, the one that got burned and the one downstairs that had water damage. Now, my question is, the work that is required to remove the lead and asbestos and do the abatement of the smoke and soot for all the remaining units would require more than 30 days. Are we allowed to request that the tenants move out? And this is because of the fire, for fire remediation.
The answer is yes, but you're going to not like the follow-up. If the work is going to take longer than 30 days, of course, you can ask the tenants to move because you got to do the work, but you have to apply to the city of Los Angeles for something called a tenant habitability plan, a THP, tenant habitability plan. That's where you apply to the city. They will authorize you to force those tenants to move. You have to give them accommodations for the time that they're out. So you have to find places for them that they're willing to accept. And then, of course, they have the right to come back after the work is done. So you're going to pay relocation. You're going to have to find places for them to live. And then they have the right to come back. Now, a tenant can choose not to come back, just take the relocation and go. But otherwise, you have to pay for that housing, and then they have the right to come back.
But even if this is as a result of a fire, which is not the landlord trying to do any type of remodeling, or, this is not, according to some Los Angeles County, if the work takes more than 30 days, then due to a fire, then the landlord has the right to relocate them. Is that what I understand?
I don't know that to be the rule, and we're not talking about Los Angeles County in any event. We're talking about the city of Los Angeles, and they have a specific tenant habitability plan, THP. You can contact the city and they'll explain the process to you, but these people have the right to come back, and I don't think it's any different for unincorporated areas of LA County as well. And the fact that this was a fire and I'm not doing renovation, that's irrelevant. The tenants have the right to come back. So.
Yeah, got it.
All right. Thank you, Saul. I'm going to move on here. Let's see. Did we talk to Rick R? I don't think we talked to Rick R. Rick R, how are you, sir? Please unmute yourself. There you go.
Hello, Dennis.
Hello, Rick.
Okay, thank you very much for being here. My case is a little complicated as well, but most of them are, I guess. I have a single family residence in the unincorporated area of the count of Los Angeles County. It's in Antelope Valley. The tenant couple moved in March of 2021. About 3 months later, the tenant had a job loss. Then they, claimed all the COVID stuff. I did a notice last summer, and we got eviction defense money for about 9 months. That went through August of last year, 2023. Supposedly the tenant, had been saving up money, et cetera, and was going to catch up and pay. But he told the property manager he was coming in on this Monday, and he was paying 1 month's rent, which means he is going to be 4 or 5 months late. So I applied for the.
Let me stop you here.
Sure.
You got rent. What I'm hearing from you is you got rent through August of 2023
from the
from
LA.
any source. You got the rent through August of 2023.
Yes, eviction defense
Okay.
fund. Yes.
And so right now he owes September, October, November, December, January. That's 5 months worth of rent. He's offering to give you 1 month's worth of rent.
Well, yes, but I'm trying to get him to join the LA rent control landlord program, which you probably know about. I applied for that, and he has to join the portal. And I'm applying for September, October, November, December. They don't go beyond December. I don't know if he's applied for that or not. I don't have a very good relationship with him, and he's going to be meeting supposedly my property manager on Monday.
My good friend.
Yes.
Can I ask a question?
Yes, you can.
Why are we doing this? Why don't the guy hasn't paid you rent in 5 months, okay? And actually more, because the money didn't even come from his pocket. This just doesn't seem to me, call me silly, it just doesn't seem to me like a great tenant. And you have every right in the world to terminate this tenancy based on failing to pay 5 months rent. What's the problem? And by the way, you could have done this 4 months ago.
When we were in court last summer, he requested a jury trial, and he has a jury trial defense lawyer, supposedly, who was going to help him do that. We did the eviction defense fund in lieu of that. So with all the tenant protection and lawyer help that he gets, and he got a free lawyer, by the way, for that.
Well, of course he did.
I'm just afraid he's going to say, I want the jury trial again.
Absolutely. Your fear will be realized without question. So, and if you're afraid of a jury trial, which can happen in any particular eviction case, then the alternative is let him live there forever for free. That's what you should be doing. Let him just live there forever for free. Why don't you consider him your son and daughter? And you have an extended family now, because if you're afraid to take legal action, because he's going to ask for a jury trial, you're right, he's going to ask for a jury trial. It's not the end of the world. We go through the jury trials. The last 5 jury trials we won out of my practice. Does it cost you a little money? Of course it's going to cost you money. However, how much money is it going to cost you to let him live there forever for free? What's his rent per month, for example?
2,000 is $19.95.
So right now you're up to $10,000, right? Doesn't cost you $10,000 with me to do a jury trial. For most parts, it's much less than that we get you out of this. But
excellent.
But again, and I'm not trying to garner more business, but in 5 months it's 10,000. In 10 months it's going to be 20,000, and let's just keep going down. So unless you want to adopt them, and by the way, I do not do adoptions. Okay, just let you know it's not part of our legal service. But otherwise, you're adopting this person. Get rid of him. Okay, anybody would do that. Okay, my friend.
Yes, sir.
Okay, sorry for the tough love, Rick.
Well, I'll probably be calling your office. The other case was dismissed
Yes.
you know, when we got the eviction
When you got the
defense
money, right?
So,
But the guy has a proclivity that he will never pay you. He will always
correct.
look for somebody else to pay us. So we're going to have to bite the bullet. You know, eventually you're gonna have to get the surgery. You know, you
Yes.
can only go so long. We know what that means.
Yes.
Okay.
Thank you.
Rick. Anyway, nice talking with you.
Thank you.
I like Rick. Let's move on. I see another cell phone here. I think it's, I don't think we called on this one. 9587 is the end. If I'll ask you to unmute yourself by doing *6.
Hi, yes, this is Jennifer.
Hello, Jennifer.
Hi, I have a question. So I have a single family home that I'm renting. The tenants have been there for over a year, but after the year lease was up, we did month to month. So I just want to clarify if I have to give them the 30-day notice to quit or the 60-day.
Okay, so there was a 1-year lease and now it's month to month?
Yes,
What city, please?
Los Angeles.
Okay, well, in Los Angeles, you can't just serve a 60-day notice. All residential units are under just cause eviction. So you have to have a reason to evict. So the next question is, why do you want them out?
My daughter will be needing to move in.
Okay, so if your daughter needs to move in, you certainly have the right to do that. We have to file an
Okay.
application process with the city first. Once that goes through, then we can serve a 60-day notice with the approved application to your tenant, and we have to pay relocation money. The relocation money for a single-family home is 1 month's rent. But we certainly have the right to do that. But you can't just serve a 60. We got to go through this process with the city and then pay the relocation.
Gotcha.
Okay. So
Okay, thank you.
You're okay. Thank you. Okay, let's move on. Let's move on to, I see, it looks like Conrad Allen. That's what it looks like to me. I'm going to ask you to unmute yourself.
How are you, Dennis? Thanks for taking my question. Thanks for doing this. Very informative.
Thank
My
you,
question
sir.
is this a good time to buy a multifamily property in Burbank?
Well, my office building is in Burbank. Burbank does not have any local rent control, but every city in the state of California has rent control because it's statewide rent control. Burbank has been threatening to institute rent control. Right now, if you wanted to get those tenants out, you could just do the excuse of renovating the unit and actually do the renovation. You could remove all the tenants. How many units?
Maybe like a 6-unit property.
Okay, so right now you can raise the rents if the current owner hasn't raised it 8.8%. If that makes you happy and that will seal the deal for you, then you don't do anything other than get the property, raise the rents 8.8% under current state law. However, Burbank has been threatening to institute rent control. So I don't have a fortune ball here, fortune teller ball, but it's if they do institute rent control, then you're not going to get 8.8%.
Okay. Thank you very much.
Sir.
Appreciate it.
No problem. Let's see. I am going to pick on another cell phone that ends 3041. I'm going to ask you to unmute yourself by hitting *6. Anybody there at 301?
Hi. Hello.
There you go. Hi.
Hi.
Hello.
Hi, Dennis. I am LARSO. I've given a 3-day notice at the beginning of December. So much has happened since then. Anyway, utility, it seems as if the tenant may have moved out. I think I could see like a mattress through a window, but and on the security cameras, I saw like a U-Haul and things being moved out. And this week, utilities seem to be disconnected.
Let me stop you here, darling. Everything you're saying is so clear that this tenant is moved. What you need to do is serve a 24-hour access notice that you're going to check the dwelling to see if in fact the tenant has abandoned. That form is on my
Okay.
website at evict123.com. That's evict123.com. All you need to do is put that on the door, go on in. You're going to see everything is out of the unit. You already see the cameras with the U-Haul trucks. You see that the utilities are turned off. You can take possession of this property. So just go on in, take some pictures, confirm the fact that no one's living there and that the utilities are off, and the place luxuriously is yours.
Do I have to, I've printed out your 24-hour notice already. And
Good.
also I saw this notice of right to reclaim abandoned property. Do I need to do that for that?
Well, it all
stupid
depends. If
mattress?
there's something left in the unit of true value, okay, then yes, you should fill out that additional form dealing with abandonment of personal property. But if it's just garbage in there, go clean it up. I think you're obsessing a little bit. Go take possession of the property and go rent it to somebody who's going to pay you the rent.
So this would protect me from him coming back at me. Oh, and then
Well, how is he going
21
to come
days
back
to
at you?
do
The
this.
utility, stop. How is he going to come back at you? The utilities are off. Everything's out of the unit. You got pictures of a U-Haul truck. No one's coming after you. I think you're being a little bit too secure-minded in this. So serve the 24-hour notice.
Okay.
Go in, take pictures, and enjoy your return of your property to you.
I already started an eviction. The papers have that they attempted for the third time to do the summons, but of course they couldn't serve it because no one's in the unit. So papers have.
Again,
I don't know what I'm supposed to do.
I think I've told you. I'll tell you one more time. I feel like I'm in the
Okay.
office here. Serve the 24-hour
Sorry.
notice. Go into the unit. Confirm the fact
Okay.
that the tenants have vacated the unit. Certainly, if there's no power, no one's living there. And then call your wonderful attorney and tell them, hey, the tenants have gone and I've taken possession. I love you. And I'm going to take one more call. Let's see here. One more call, and let's take, is this another cell phone? I think I see another cell phone here. I don't know if I've taken this one. Looks like it's calling from Las Vegas, but it's N7337. I'm going to ask you to unmute yourself. There you go. Are you there?
Yes, sir. How are you doing? Yes, sir.
I'm
Can you hear
good.
me?
Good. Are you calling from Las Vegas?
I am not, sir. I'm calling you from El Paso now.
Oh my God, you move around. You got a Nevada area code.
Yes, sir. So my question is referring to a LARSO.
Yes.
Now, there was some testing done, and there was lead and asbestos found in 2 units. Am I obligated to fix the other units without, or am I obligated to test the other units to verify?
Well, yeah, I would test the other units, but again, generally with asbestos, which is in a lot of buildings, and lead, which is in a lot of buildings, but as long as it's not disturbed, then there's no problem. So you might want to do some spot testing just to make sure, but obviously you're going to have to remediate the ones where there was an issue.
Yes, sir. So if these 2, if the other units do show up positive, am I obligated to I guess to remediate that issue?
Oh, of course. If they've got lead, exposed
Okay,
lead
gotcha.
or exposed asbestos, then that certainly is your obligation. You might want to check with your insurance company. They might be able to assist you with that. And with that, ladies and gentlemen, I am going to say thank everybody for coming. I want to ask everybody, if you're listening to this on YouTube, please subscribe to my channel. It does help in deferring some of these costs for me. Not that I'm looking for income off of this, but it just defers the cost. So if you could subscribe to my channel, I do appreciate that. And if you go to my Twitter account or to my YouTube, I did a wonderful 1-hour seminar with another gentleman, and that's going to be posted online, and I'll give you some links to that. But once again, thank you, everybody. And you know what? Let's do it again next week. Next week, Saturday, I'll be here and get your questions ready. Appreciate everybody.